Good morning.
Good morning, Judge.
Good morning.
Good morning. Mr. Folkston.
Yes, sir. Can you not hear me?
Are you listed on any of the briefs or anything? I understand you're going to be arguing this morning.
I'm listed on the signature line of our brief. I'm listed on the signature line of motions we filed. And I, this morning, did file an entry of appearance on this case and sent that to Mr. Whalen. And I believe I just received a notification that it was accepted.
Good. Just want to check with you. Okay. Good morning, everyone. My name is Henry Green, and I will be the presiding judge in this case. And this is the case of 121023 in the matter of the marriage of Timothy Gronlie, appellee, and Rachel Lynn, appellant. Appearing with me as judges is Melissa Taylor Standridge and Patrick D. McInerney. And let me get the appearance of counsel. Appearing for the appellee, Andrew Folkston. Do you have a middle initial?
L, sir.
L. And appearing for the appellant, Rachel Lynn, is Michael Whalen.
That's correct.
Now, thank you. Mr. Folkston, do you want any rebuttal time? This case has been set for 15 minutes.
Yes, Your Honor. The respondent is the appellant.
Okay.
So
Mr. Whalen, will you want any rebuttal time?
Yes, Your Honor. With the court's permission, I would ask for 4 minutes.
Are you ready to proceed with your argument?
I am, Your Honor.
Ready to hear it.
Thank you. Good morning. May it please the court. Michael Whalen on behalf of Rochelle Lynn, the appellant in this matter. It's a pretty straightforward question, I believe, for the court today. In May of 2016, Dr. Gronlie and Ms. Lynn, they had 2 children. They had 3 children, but the second child aged out of child support, turned 18 at that time. In, I believe, September of 2017, in response to a motion, Ms. Lynn, by motion, made a request for a change of child support based upon the aging out of the other child. After an evidentiary hearing in which this was included, the court made a finding that child support should be adjusted, came up with an amount of $1,160 per month, commencing December 1st of 2017, as Ms. Lynn had filed her motion at the end of November, I believe the 29th of 2017. The issue, or part of the question that we have for the court today is, was it appropriate to start the new child support calculation at the time of following the filing of the motion, or should it have been, which is what we believe, calculated by child support starting at the time that the elder child had aged out? Now, the case law, I think, for the last few years has shown we rely upon not a proportionality analysis, but we go by Kansas sentencing guidelines, and the appropriate time to begin the change or the altered child support is at the time that the older child aged out. So that would go back to May of 2016, should have been the start date.
Mr. Whalen, can I interrupt you just briefly? To get to a more basic issue, and that is the question of mootness that has been raised by the appellee. That was raised in his brief, and there wasn't any reply brief file that I could see. Is this moot?
No, Your Honor.
Tell me why it's not.
Well, the way the appellee presented it is Dr. Gronlie had been paying $2,000 a month for the year of 2016. I guess, by agreement.
Right.
In Kansas, child support accrues monthly, and they become final judgments on the date that they become due and unpaid. And that's, I mean, going back to 1966 in the Briger case. We don't look at the accumulation of all the funds that have been paid. Every month, X amount is due. Dr. Gronlie chose for the year of 2016 to pay $2,000 a month. It wasn't court ordered. And that's also noted in the appellee's brief that the parties cannot alter a child support order by agreement or on their own. So even though he made those payments, and this is why we got in the brief, and there's a question about when do we start this, and you know, the beginning of 2017, because he had overpaid previously. But that child support is a monthly payment. You can't, without approval of the court or a court order, prepay your child support obligation. So the fact that he paid $2,000 a month previously doesn't have an impact on what he still owes, which would have been, if we go by, if the court were to accept his $2,000 a month as covering the $1,160 a month, and we look at it starting in January of 2017, there's an additional I had the number, $1,760 that is still accrued and is owing by Dr. Gronlie for the underpayments that we have going back. There's not a moot.
Did he pay that $2,000 directly to her, or did he pay it through the district court trustee?
I do not recall, Your Honor. I believe that it was through the trustee, but I just remember that the evidence was that he had agreed to pay that amount through the end of 2016.
Well, isn't that because his former wife was reminding him that he needed to pay that under the order? The order had not been changed?
Yeah, that's correct. And he agreed to make that payment. I mean, I don't know that it was expressly, I believe you're correct, Your Honor, in that she was saying, this is what the order says, you need to keep paying it. He did. He didn't seek a modification of the order at that time either. And so again, it becomes a voluntary matter. And if we go back, and that's why we looked at within our brief of starting the payment date of being January 1 as being the start date, quote unquote, because he had been paying the overage or the other amount previously. But I don't believe there's any case law that says you can aggregate what somebody has paid and then just spread that out over the time past. And because each monthly payment, when it comes due, is an independent judgment, that is the amount that is owed for that month. And so he underpaid then by paying $1,000 a month from January until December when the new order went into place. Does that adequately answer your question, Your Honor?
Well, I'm trying to understand the paying it through the district court trustee, say this overage supposedly of $2,000 a month. That, of course, we don't want that to happen. We don't want payments to be made outside of the trustee's office when the trustee's handling the collection of support payments, because then you get into he said, she said battles over whether or not payments were made and whether they were and why they were made. Here, the record is that if that's true that it went through the trustee's office, that obviates that concern, doesn't it?
I'm sorry, what concern, Your Honor?
Well, the concern that underlies the fact that we don't want voluntary payments counting against support orders because of the evidentiary problems of establishing whether or not, when it's supposed to be paid to the trustee, whether or not it was simply a voluntary payment or a payment that was being made through the trustee's office pursuant to an order.
Well, but then we run into the same issue because his overage would have affected the start date in December, if I'm not mistaken. Then it never should have started. I don't believe that I'm familiar with any time where we aggregate all the payments to see how much there is. And that's what I'm saying, that regardless, as we came into January and those payments stopped, he still had a monthly support obligation of $1,160. That was not included in the court's order.
Right.
So he may have been making appropriate payments at that time, but those were payments that he believed following an order that were being made. They stopped. It went down to $1,000 a month. We believe that in January, it should have gone back up to the 1,160.
Mr. Whalen, what happens when someone makes an overpayment? Let's say not under these circumstances, but in a different circumstance. You know, I know that we have arrearages that are assessed against, you know, someone who hasn't paid enough. But what happens when there's overages? It's just, I mean, are there any cases, or does the statute contemplate that?
There isn't anything that I've come across, Your Honor. I believe that that the requirement would be on the payee to come to court and either request, you know, finances back based upon the order, but that didn't happen here. There wasn't, and that's why I think I put in the terms of this was agreed or something that he chose to do through the end of the year. But he also would have received, I mean, I think this is the point. At the time that the other child aged out, his payment based upon the proportionality and the trustee request went down to $1,000 officially. He was paying the $2,000 not because that was the order at the time, because it changed automatically as they do in Sedgwick County. I think all counties in the state. Once that child aged out in May, his actual obligation dropped to $1,000. So he was overpaying by choice, even if it was, you know, my client saying you need to keep paying this because there's been no change in the order. I believe the order would have had change. And that's part of the issue about, do we follow the Kansas sentencing guidelines versus the Brady?
I think you mean the child support guidelines. That's the second time you've said that.
I'm sorry?
You keep referring to the Kansas sentencing guidelines.
I've done more criminal work than I have domestic work, Your Honor.
Yeah.
Yes, the child support guidelines, that would not be very unfortunate, I think, if we were applying those in this situation. So I think that under those circumstances, it does wind up being a choice to make the continued payment. Even if it was mistaken, he said, okay, I'll do this. And it didn't come up until there was the motion to change later on. Because at the end of 2016, he started paying the $1,000 a month, which was actually the in place, or I guess it's an order, but it's what was then promulgated by the court trustee as to what his payment obligation was. So, I mean, I think those are, yeah, I don't believe that it's a moot issue, Your Honor. Those were payments above what was ordered at the time, and the order that was in place based upon the actions of the trustee. And unless the court has other questions, I do believe this is kind of straightforward. We either go back, either the timing of this, when the payments start, go back to the time that the child turned 18, or we go by the filing of the date under Brady, not Brady, but where we go to the statutory date of from the month, the time that the motion was filed. And I think that from case law from Winsky and Vandervoort, both of them say age out, you go back to the time that the child turned 18. Thank you, Your Honors.
Thank you. Mr. Poston?
Yes, sir. As Judge McEnany pointed out, our first argument on this case is the mootness of the appellant's appeal, specifically that Ms. Lynn has received more in child support payments than she would be entitled to if this court were to reverse the lower court's decision and change the effective date of the new child support order. There's essentially three things the court needs to consider to decide this question. First, when could the district court could have gone back to? Ms. Lynn has suggested January 1st, 2017, or the date the child aged out, which was July 1st, 2016. The second is whether Ms. Lynn would be entitled to any more money if the court could go back, depending on what dates the court could go back to. And then the third thing the court needs to determine is whether any exception to the mootness doctrine applies. As to the first issue, when could the court have gone back? I provide a long string cite in the brief that I don't necessarily want to recite here, but it seems that every court that has decided this issue has found that the date that you can go back to is the date the child aged out. KSA 3005B says that you can only go retroactive to the first date following the filing of the motion to modify. Here, that would have been, it would file November 29th. So the earliest under that statute you could go back is December 1st. So the only way you can go back farther than December 1st is if to correct a miscalculation, according to the court in Vandervoort, excuse me. So the only possible start date of any miscalculation would be July 1st, 2016. There doesn't be any support for going back to January 1st. The only basis for going back to January 1st is that is when the father stopped overpaying, but there's no basis in law that is a date to which a court can go back to. It appears very clear here that the court needs to go back to July 1st, 2016 to correct an alleged miscalculation, or it can go back to December 1st, 2017 under the statute. So going as far back, and the best case scenario for the only thing that would change anything is if you go back to July 1st. So doing the math, which is a dangerous proposition for lawyers, admittedly, it appears that Dr. Gronlie paid approximately $23,000 between July 1st, 2016 and December 1st, 2017. Had the order for $1,160 per month gone back to July 1st, 2016, Dr. Gronlie would have only owed $19,720. Therefore, even if we accepted that the court made a mistake in not going back to July 1st, 2016, Dr. Gronlie has already paid more than Ms. Lynn would be entitled to under that order for that amount of time. So there's really no relief this court can grant Ms. Lynn that would provide her any sort of benefit. The court can only, at best, I'm sorry, did someone have a question? I heard something, excuse me. At best, the court can say, yeah, the district court made a mistake. If you calculate it out based on a new date, Dr. Gronlie doesn't owe any more money. So there's no more relief this court can grant. There's nothing effective this court can really do for Ms. Lynn. As cited in our brief, the two analogies that were probably most on point were the Dickey Oil and Pew case. In Dickey Oil, that was the overproduction of oil that was equalized prior to the decision, and the court said there's nothing we can do for you. Even if we granted your appeal and granted judgment in your favor, you wouldn't be entitled to anything more than you've already got. And that's exactly what's going on here. She's already received as much, and in fact, more child support than she'd been entitled to if the court were to go back to July 1st, 2016. Similarly, on Pew, the plaintiff agreed with the defendant not to collect punitive damages. So the Court of Appeals could not grant the plaintiff any more relief by overturning the district's court decision not to allow punitive damages, because there was no more money the plaintiff could receive. So they weren't legally harmed, is what the court said. And this is exactly the case here. Ms. Lynn has not been legally harmed by the decision to use December 1st, 2017, as opposed to July 1st, 2016. In fact, she's arguably better off from a financial standpoint. The only two exceptions to the mootness doctrine are that the issue is an issue of public interest and that it is capable of repetition while evading judicial review. First, the public interest is a pretty high bar. Smith and Miller, it was the constitutionality of statutes. In Associated Press v. Sebelius, it was the application of statutes to public officials. That's simply not the level of impact we're facing in this case. It's I don't want to say minor, but it's not as large as the constitutionality of statutes or the application of the public officials' ability to, and the application of statutes to them. And then as to the capable of repetition while evading review, there's really no indication of that. I mean, this is an issue that could very easily be reviewed in a future case where the recipient actually has received less money because of the decision to go back to a certain date, as opposed to the decision to go back to the date after filing the motion to modify, as opposed to the date the child aged out. And that would be a better case for this court to decide that issue if it were to come up. There's plenty of time for a person to file an appeal after that issue arises. This court hears many child support cases. They're fairly often appealed, so there's no real indication that this would evade review were it to come up again. So it appears that none of these exceptions apply, and so the ultimate conclusion here is that this court really can't do anything for Miss Lynn, and therefore there's really no effective relief this court can grant her, and therefore the issue is a moot one and does not warrant a determination on the merits. Proceeding to the merits, however, if the court were to go to the merits, Brady is still good law. Brady, of course, is the Kansas Supreme Court case where the court specifically held that the proportionate adjustment was allowed. In fact, I believe under Brady, it was essentially required. Now that has changed a little bit with the guidelines, of course, but the guidelines really come into play when there's a motion to modify. Of course, when there's a motion to modify and it's before the court and the court's going through all the factors, the court has to follow the guidelines. We don't dispute that. However, there's nothing to indicate that a automatic adjustment made by a trustee or some other entity appointed by the court is not allowed. There's simply been no case law to indicate that. All the cases that indicate that the proportionate adjustment are on motions to modify or where it specifically comes before the court to determine the child support owed after a child aged out. And this is a practice, the automatic adjustment is a practice that is widely followed throughout the courts. It's just a simple, easy, effective, inexpensive way to recalculate the party's child support obligations after a child ages out. The most on-point case is the Burton case from 2001, where the father, of his own volition, not using the trustee, stopped paying a certain amount of child support after one of the children aged out. This court first held that it was proper for the father to automatically reduce the child support under Brady. However, the problem in that case was the father had just reduced by the amount he was paying for the child that aged out instead of a proportionate adjustment as specifically contemplated by Brady. But I mean, specifically on point, the court said that Brady still applies. Brady permits a pro rata reduction as a matter of law without the necessity of returning to court. So that's specifically what happened here. That's the most on point case, and specifically, there's been no Kansas Supreme Court case overturning Brady. And that's also what this court said or implied, at least in Nelson, which was a case very similar to this one, in which a child reached 18. It looked like there was a motion for modification, and this court still said that Brady was still applicable, still applied, and that proportionate reduction was still appropriate. Of course, there have been two cases since then, Winsky and Vandervoort, which the Ms. Lynn relies upon. However, again, the key difference there is that both those cases are when the matter actually came before the court to consider what the child modification or child support modification should be after a child ages out. And like we said, we don't dispute that if that happens, if it's before the court, if it's on a motion or some other motion to modify or for some other reason, that issue comes specifically before the court, There's evidentiary hearing. The court has to consider all the factors and apply the guidelines. But that is not what happened here. Instead, it was a simple automatic adjustment. Had Ms. Lynn wanted to file a motion to modify, it's clear that that is a event that qualifies her to file an immediate motion to modify if she was not happy with the proportion of adjustment, if she did not believe it was appropriate. The fact that she did not do so until November of 2017 does not allow her to go back and go back to her original, the original time when she could have filed that motion. Instead, if she goes, it's clear under the statute, she can only go back to the month after she files it. Besides the Supreme Court precedent Brady not being overturned, there's also a pretty significant practicality consideration in this case. Were this court to rule that a trustee or whatever entity the district court has assigned to handle the payment of child support and withholding orders cannot just enter an automatic adjustment when a court, when a child ages out, it's essentially going to turn every time a child ages out or stops receiving child support as a de facto motion to modify child support. Every single time we're going to have the parents come into court. We're going to have evidentiary hearings. We're going to have these are long, lengthy hearings. They're often appealed to this court. They're often very contentious. They're generally not good for the parenting relationship between the parents for the children. And that's simply just not necessary. It's not necessary to bring everyone in, even when they don't themselves see a reason to file a motion or a motion to modify. That's exactly what Brady said, is that it's much more preferable to automatically adjust proportionally, because then neither party has to seek immediate court order to alter a child support obligation. And then of course every parent still does have the remedy of filing that motion to modify if they so wish, but there's no reason to drag people who don't want to be in litigation over the automatic adjustment into litigation. So for those practical reasons, it's really would have a pretty substantial impact and pretty heavy burden on the district courts were the automatic adjustment not to be allowed anymore. Because again, every single time, excuse me, the parents would have to come back into court and relitigate the entire child support arrangement. So just to reiterate, there's two reasons we're asking that this court deny the appeal. First, the issue is that simply, even if the court were to grant judgment in Ms. Lynn's favor, she simply would not be entitled to more money than she's already received. And this court should follow the general rules that, someone shouldn't receive should essentially be receiving a double payment for the same thing. She'd be getting more than she was entitled to for the first 6 months, and then she'd be getting the $160 more for the next 11 months. And she can't have it both ways. She needs to have it accept the amount she's gotten now, or accept the amount that the court ordered, which would be less than she's gotten now. So for that reason, this issue is really moot and doesn't need to go to the merits. But even if it did, as I discussed, the Kansas Supreme Court precedent is still out there. It still appears to be good law. It certainly hasn't been overturned specifically by the Kansas Supreme Court. And also there are these pretty significant practical reasons for allowing the automatic adjustments to continue. And so for these reasons, we'd ask that this court either decline to address this on the matter of mootness, or to just affirm the substance of the district court's opinion. And if the court has any questions, I'd be more than happy to answer them. But otherwise, I don't have any more argument for you today.
I don't see any questions, Mr. Poston. Thank you.
Thank you.
Mr. Whalen, you have your rebuttal time.
Thank you, Your Honor. Well, I think one of the arguments against mootness is one of the things that was just brought up. There is a public interest issue in this. If a motion is filed to modify custody or modify child support, when does that time start if it's based upon a child aging out? because we seem to have a controversy about, is it filed, does it come to time at within the month after the filing of the motion, or does it go back to the time that the child aged out? And the child aging out itself is a financial changes situation that would support a motion to modify child support. So the appellee is kind of, you know, wanting their cake and eating it too. There's no public interest here, but you know, this should follow the statutory rule as opposed to kind of the judicial rule, which we have, with that it goes back to the time that the child becomes an adult and ages out, and there's a change at that time. And I think that is the issue, or one of the issues, that the court needs to address in this matter.
Is that your position, that the court's order modifying support is retroactive to the date the child aged out? Or
Yes, Your Honor.
the months following the date that the child aged out?
Yes, Your Honor. And I think on the I think it requires a motion to modify. I'm not saying that it's an automatic occurrence, but there is a basis then for, you know, one parent to come in, file the motion, and then it goes back to the date. And I believe that that's actually what the answer was in Winsky and in Vandervoort.
All right. Is there any prohibition from against a child support payer who's paying through the district court trustee to pay child support in advance of the court's order?
Well, it would be a violation of the court order. If the order says you are to pay this amount per month and you're paying more, I believe that's a prohibition. I mean, that's where the line stops and it becomes a voluntary overpayment by the individual, because they're no longer in compliance with the order of the court, which is, you know, say it's $1,000 a month. That's the court order. Well, this isn't a mortgage. You don't get to reduce your interest by paying extra on your monthly than what the minimum payment is. I don't believe that there's anything that supports a voluntary prepayment of child support.
Or anything to the contrary, is there? In other words, let's say I'm a real estate agent, and my income fluctuates dramatically, and I hit the jackpot on earning a commission, and instead of and I decide I will prepay through the trustee's office child support to cover the dry period that I expect for the next couple of months. What's wrong with that?
One, I don't think we're set up for it. Two,
because
I would assume as a
it's an accounting system, and all the trustee does is enter money in, money out, and if you have a negative balance, then you're in default. If you have a positive balance, it seems to me like you probably have a credit, don't you?
No. I mean, Your Honor, that's why as a real estate agent, you would have a bank to save your money in the event of such a change coming up. The court trustee is not your bank. It's not designed for that. And you are, I think, technically in violation of the court order by overpaying, because you're not following the order of the court to pay X amount each month. And I think that then what happens later on? Say you never hit rough times again. Do you just get to stop? Are you then allowed to stop monthly payments because you have extra in the bank?
If I am in default because I've missed a couple of payments, and in 2 months, and on the third month I make my regular payment plus I make an additional payment to start making up the arrearage, I'm in default of that month also for having overpaid. Is that what you're saying?
I don't know that it's, and maybe it's a term issue, Your Honor. I don't believe that you're necessarily in default, but you're not following the order of the court, which is X amount per month. And I think that you're then looking at expanding the role of the court trustee and would that then, Your Honor, because you paid extra, allow you to stop making payments for the rest of the year because, hey, I have enough in there? And is that going to be acceptable to the court? Because that's what it sets up. I can just make a lump sum payment to the court trustee and leave it to them to make the monthly payments off of that. I would think, unless that were allowed by a court order and by the approval of the court, that would not be an acceptable means of proceeding and paying child support. I'm unfamiliar with anything like that occurring, Your Honor. And with that, unless the court has other questions, I thank you all for your time today. This was very interesting doing it by Zoom.
I don't see any other questions, Mr. Whalen. We appreciate your argument and Mr. Poston's argument. And this court will be adjourned. Thank you.
Thank you, Your Honors.